For the Honorable, the judges of the Court of Appeals draw near and give your attendance, for the court is now in session. God save the people of South Carolina and this court.
Thank you. Please be seated. Good morning. All right, Madam Clerk.
Your Honor, we have case number 2020-001075, Jefferson Davis Jr. versus Nate Leupp.
All right, Mr. Davis. Sir, if I'm going to get you to stand for me. I understand that you are a lawyer but not a member of this bar. Is that correct?
That's correct, yes, sir.
That being said, I think only because years ago when I started doing this with self-represented litigants, I need you to raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir, I do.
All right, sir. We're glad to hear from you, sir.
May it please the court, my name is Jeff Davis. I am the plaintiff appellant in this case, and as the Chief Judge Williams noted, I am a licensed attorney in the state of Georgia, but I did go to the University of South Carolina and never took the bar exam. In the old days, you could literally take the bar exam in Georgia 6 months before graduation, and I took it, passed it, and I wasn't coming back and taking another bar exam. So in hindsight, I kind of wish I had now that I moved back to South Carolina, but that was the case. I don't know if they still allow that, but that's why I'm not a licensed member of this bar. So what this case is about, I sued the defendant, respondent, a gentleman by the name of Nate Leupp.
Is that how you pronounce it?
Nate Leupp, I think it's
Leupp, okay.
Leupp, yes, sir. He is a political figure in Greenville County. He was the former chairman of the Greenville County Republican Party. He was my immediate predecessor as chairman of Greenville County Republican Party. I'm no longer the chairman. I'm now the state executive committeeman. So I was elected in 2021 and then elected to be the state executive committeeman in 2023. So it's a bit of a political battle that part of this is all wrapped up in. That's
May I ask you a question? Forgive me for interrupting.
Yes,
But as I understand your position, you say that sure, there's some common factual background between this case and the Richland case, but you really can't overlook the fact that some of the stuff in the Greenville case occurred after the filing of the Richland case. So you can't say it's 12B8. It might be other things, but it's not 12B8.
correct. Yes, sir.
I think part of your friend's argument, and I'm not being critical of anybody's position or anything anybody has done in either litigation. I'm just trying to be descriptive, and so I want to be clear about that. I think part of your friend's argument, and I may be wrong, is that the way you went about filing these cases is an abuse of the court system, for lack of a better way to put it. And here's what I mean. Judge Benjamin dismissed some claims in the Richland case, asked you to name John Doe defendants, and gave you time to amend. And I know you've got problems with the way that went down, and I understand that, and some of those problems may be well-founded. But in response, you named new defendants per her order, but you also repled all of the claims from the first complaint, even ones that she dismissed, and you added new John Doe defendants. So what, again, I'm not trying to validate his concern, say that he's right when he says it's an abuse of the court system. I'm just trying to be descriptive. But that's what I take his argument to be. How would you push back on that?
I push back, number one, just to give you a little bit of background. I am pro se. I'm a tax attorney CPA. I'm not a litigator. So, yes, I did leave some of those things that Judge Benjamin had dismissed previously. That was a mistake. I'm happy to take those out. In that sense. I will tell you that subsequent to filing this appeal, this Court of Appeals in that case has dismissed my appeal, saying that those plaintiffs that were newly added were not added to the litigation. And in fact, which includes Mr. Leupp. And it also, this court has ruled that complaint was never even filed. I disagree with that to a certain extent, but this court has ruled that that was not filed. So not only in this case, the 12B8 case, the Greenville case, Mr. Leupp was named as an ancillary party, just mentioned in that complaint once, because Judge Benjamin did order me to name any potential John Doe in that case.
But
He also was not served, and he was in that complaint was never technically filed.
I thought in the Richland appeal, I thought the only part of the case that was up on appeal and decided here was the dismissal of the new defendants, and that was based on the interpretation, Judge Early's interpretation of Judge Benjamin's order that you had to name and serve within 15 days, but that the lawsuit lived against other defendants. Is that right, or?
It only lived against the original defendants, not the new ones. And if you look in that order that was filed, I think I filed it with this court, a courtesy copy on September 6th, 2020. It says, moreover, Mr. Davis previously had an opportunity to amend the complaint and failed to comply.
Right.
So to me, Mr. Leupp was never named. I mean, he certainly was never served.
And that's what I take your argument to be. It's not commenced against him because an action is not commenced until you're served or appear.
Correct. Absolutely, Your Honor. And that is the simple 12b-8. Then 12b-8, as this court or our state Supreme Court has ruled, has to be interpreted narrowly and in very limited circumstances. So with that three-part test under 12b-8, there has to be another action pending. There was none, as this court has now ruled. It has to be the same parties. There were substantially different parties, and it has to be the same claims. The claims in my Greenville case actually, in large part, occurred after the filing of even the amended complaint in the first case. So that's essentially my entire argument, if you will. So, but, you know, I don't know how much detail the court would like me to go into. I mean, there are two different cases out there. The first case, the Richland case, was perpetrated basically on some 2016 actions where our now state superintendent of education, Ellen Weaver, was telling people that I was disbarred from the practice of law. Back to my point that I've never been a member of the South Carolina State Bar, I believe my intent belief is she looked up she knew I was from South Carolina. She knew I went to the University of South Carolina, got my law degree and MBA there, went to Citadel undergrad. I think she just didn't see my name on the bar list and thought, you know, if your name's not there, you must have been disbarred. So she was telling large numbers of people across the state, and I suffer from it to this day, where I have people wondering where, and it was actually in this case as well, in the Greenville case, why I was disbarred from the practice of law. Nate Leupp, in this Greenville case, has substantially walked around that town, my county, and told people that I'm disbarred from the practice of law. Some of those actual instances occurred after the Richland case and after the amended complaint was filed in November of 2018. So these were actions that were actually occurred in 2019 involving the Greenville County Republican Party elections then and even subsequent to that. So to me, you know, that's where it all started. This is substantially different with Mr. Leupp and what he has done in Greenville. That includes a website that actually says I forged documents in a bank case down in Georgia. I actually, all of this type of stuff, I continue to suffer from it because I've actually got a videotape from earlier this year where a president of a local county Republican Party said that I was convicted of a charter school crime. I've never been convicted of a crime. I've never been indicted for a crime. I've never been accused of a crime as far as I'm fully aware of, and certainly never been even questioned by a police officer. But at the same time, I've got that. When in the same video, I've got people confirming, a sitting South Carolina state senator confirming that she and this person had met with the South Carolina GOP and their legal counsel, which I do believe Mr. Chambers represents, and the SCGOP and their lawyers had confirmed these issues. So what I'm doing is standing up. I'm representing myself. Yes, I do not think this is the way we should conduct ourselves here in the state of South Carolina. I do not believe it's the way we should conduct ourselves in politics. Mr. Leupp is known for doing these types of political tactics and tricks. And if you look at, you know, certainly from what I do know, the limited knowledge I have, I've got a lot of knowledge on the tax code, and I'm happy to discuss that all day long with the other geeks out there. But I mean, if I read, you know, 12b-8, this matter is not duplicative. And if I look at the state Supreme Court cases, you know, the test and how it's supposed to be interpreted narrowly and in limited circumstances, I believe this case is substantially different than the Richland case. So that would be my argument. Any questions?
Thank you, sir.
Thank you.
All right, let's see, Mr. Chambers. Yes, sir. Be
Thank
glad to
you.
hear from you.
If I may please the court. To me, this is a very simple case. We went through everything at the lower court. We narrowed it down to what was actually pled that was actionable, and then eliminated that. And in eliminating a lot of that, Mr. Davis, in his complaint in this case, helped tremendously. In item or paragraph 21, he states about Mr. Leupp, this practice has been particularly important given other false light and defamatory statements, some subject to ongoing litigation about plaintiff by political parties associated with defendant Leupp, including but not limited to false claims that plaintiff has been disbarred from the practice of law, as not from South Carolina, as bankrupted Georgia school choice program, before fleeing to South Carolina to destroy the South Carolina program. He's talking about the Richland County case there.
And you'd answer his point, forgive me for interrupting, by saying some of Mr. Leupp's conduct that he used for the Greenville case occurred after the Richland case. You'd say, well, yeah, but you could amend your pleadings in the Richland case to bring that in. This is all just a different continuation in the same.
Yeah, and
it's based on the same stuff.
He could have done that, and he also after this case, he brought another one along with co-plaintiff Olga Lasenska against Mr. Leupp. And certainly if there was
I'm sorry, where's that? I didn't know about that one.
that was a third case. It was not appealed here. It was also filed in Greenville approximately a year after this one. And it alleged, I mean, it was filed in time for anything that had occurred between I guess when the November 2018 case, anything that could have occurred there could have been pled in that one. I'm thinking that was a 2021 case, and it was dismissed. But anyway, he pleads in this that he's also pled these things in Richland County. And then we go into jurisdiction, his jurisdictional argument, and I disagree with that because there are three separate parts of jurisdiction. And the first part is jurisdiction over the plaintiff. The plaintiff filed the complaint and consented to jurisdiction over himself. The second part of it is jurisdiction over the subject matter. It's a court of the state courts are courts of general jurisdiction. There's nothing in these complaints that's outside of that. And so the decision of the court is not putting anything on my client, any requirement on my client. What it is doing is it's all of the decisions of the court were on the plaintiff himself and requiring him to do things all the way down to Judge Early's decision that these things were dismissed with prejudice, the complaint was dismissed with prejudice against the unserved defendants.
But is it right that Mr. Leupp was never served in the Richland action and never appeared in any way, shape, or form in the Richland?
That is correct.
So how can another there may be, well, I should just leave that out. How can the rule says another action is pending between them. How can another action be pending when the suit against Mr. Leupp was never commenced?
Because when we look at this in the timing of it, he had that under appeal here. And regardless of whether or not, it is true that Mr. Leupp had not been served. However, if Mr. Davis had won that appeal, and I thought at the time that there was a good chance that he might, okay? Because it's a totally new, one of those things that I couldn't find anything that happened like this before. And so I'm looking at this as, all right, he's repled the same things here in Greenville. He's got the case in Richland County in which Mr. Leupp is named as a defendant, alleging these same things. He's appealed that case in Richland County. So at the time of dismissal, yes, my client is subject to being brought in It's as if he had simultaneously filed the same thing in 2 different counties.
He's subject to being potentially sued with 2 different
Correct.
suits. Excuse me, served with 2 different suits.
Correct. And so the same things are before the court, they are before the appellate court, subject to going back before Richland County with my client's name on it, and they're in Greenville. And so that's why I say that. I mean, that really is the situation of res judicata, where basically you're picking 2 different forums, for the same thing.
Isn't it true, though, that a Rule 12B dismissal, as Richland was, and this is typically without prejudice and doesn't have res judicata effect? Now, you might say Judge Early's order says with prejudice, and that's the law.
Yes.
That's the law of that case in this litigation.
Yes, and so it did say with prejudice. I mean, typically a court would decide things based on the totality of the circumstances in front of them. And I think that the totality of the circumstances in front of them included things like name all the John Doe defendants. He had originally named 20 John Does. Well, he comes back naming 32 more people and then adds 40 John Does. And so I think it was just things like that, the totality of those circumstances that probably led to that and the judge's assessment of things at the time.
But you agree, based on the judge's earlier question to you, that it was never commenced?
I would agree that my client never made an appearance in that, yes. And that jurisdiction was not asserted over my client in the time that it was I would agree that looking at it past tense, jurisdiction was never asserted over my client in that because he was not served.
So it was never commenced against?
It was never commenced against him, but at this time, at this snapshot in time, that was not a certainty that it would not be and couldn't be, because if he had won that appeal and then served my client, then my client's in 2 different places with the same thing. And then I would have had to deal with that.
Because that's what would have been accurate and those would have been the facts.
Yes.
Here, that's not the fact, though.
It's not fact. It just is giving you the snapshot of when I made these arguments before the court, what we had. We had this case ongoing with appeal, and then the case that he had brought realleging the same things in Greenville, and which he pleads that he realleges the same things in paragraph 21.
Mr. Chambers, in my first question to Mr. Davis, this is not a question, but more of a mea culpa. I didn't mean to put words in your mouth with your argument about alleging he was abusing the court system or anything like that. I wouldn't. So I hope it didn't come across that way.
Okay.
I'm just trying to tease out what everybody's position was.
Thank you, sir.
All right, thank you.
Yes, sir. Mr. Davis, we're glad to hear from you again.
Thank you, Your Honors. As I put in my original brief, I'm being run over by a car and continuing to be run over by a car. I looked this morning in the case, in the website that's referenced in the Greenville case, therealjeffdavis.wordpress.com. It still exists today. It says on that website that I forged documents, bank documents. What do I do today? Do I have another case? Or if I file a case about that website saying I forged documents, are they going to come back and argue this Richland case where I named Nate Leupp once gives him unlimited immunity for the rest of his life about what he does to me, what these other people do to me? I mean, this is the problem, and we are one of 2 states where judges are appointed by our legislator. This is a political issue, and this is why judicial reform is a major topic that in this state is discussing what is being implemented against people. for that Richland case to be dismissed because I did not amend the complaint and serve 20-some-odd new defendants in 15 days, that's actually not what the order said. That's why, it is unusual. That's why Mr. Chambers admitted that he probably thought I could have won that case. I mean, I didn't appeal it to the state Supreme Court. I've got enough going on in life, and it just gets overwhelming. But that is part of what they try to do to people in the state is overwhelm them. I went to law school with Alex Murdaugh. Nobody is surprised about what is going on in Hampton County or a lot of other states or counties around this state. And I am a lead advocate for judicial reform, of figuring out a better way. There's probably no perfect way that's out there. But I mean, it is rather frustrating when somebody cannot get relief, when people are literally walking around falsely saying you are disbarred from the practice of law, or putting up websites that say you have forged documents. It is dumbfounding to me. So what I'm looking for is, whether it's an equity, whatever the court needs to do. But if I look at, 12B8, it has to be the same claims. He was never served. The case was apparently, per this court, was not even amended. And that first amended complaint is thrown out. So I'm back to the original complaint. I mean, so I'm just trying to get some relief. I'm trying to get some relief for not just for myself, but for other parties that are out there that are suffering these types of things in our political environment here in our state. So I appreciate the court's attention. Thank you.
Thank you. Thank you both for your arguments. We'll be in recess.
The